Hello there. In today's video I want to take a look at an interesting case involving settlement agreement or termination of employment agreement. It's sort of a severance package, and these are quite common now, especially with the likes of redundancies going on and so forth. And one of the important things that will arise will be the question of taxation. In other words, if there is a lump sum, what is the position in relation to taxation? Is it exempt or not? There is certain exemptions for lump sum payments on the termination of employment, but it will depend very much on the particular circumstances and how it has arisen and what steps as well the employee has taken, for example. And I'm talking about an employment situation, a termination of employment. There was a decision there in December, I think, of 2019 from the Tax Appeals Commission. The Tax Appeals Commission appeal or deal with appeals from the Revenue Commissioner's assessments. So in this particular situation, there was an employee who had a difficulty in the workplace. The relationship had broken down. There was allegations of bullying. There was a mediator brought in. The employee recognised then when the mediation started that the relationship was broken and that the future there for the employee wasn't all that attractive. So the employee's solicitor wrote to the employer, and between the jigs and the reels there was a sort of a severance package arrived at. And the severance package involved payment contribution towards the legal fees of the employee of 10 grand or thereabouts, but it involved also a termination payment of 65,000 for the employee. Now, the agreement then, the severance agreement, stated that there was a taxation indemnity, and it was to the effect that the company gives no warranty as to the amount of tax or pay related social insurance contributions that may be chargeable by reason of the termination payment and other arrangements set out in this agreement. So there was no tax paid, and the employee assumed that the tax, the payment, the 65 grand, as it was a termination payment, that it was exempt. The law provides in the Taxes Consolidation Act 1997 a number of exemptions in this sort of a situation, and the three that I want to bring to your attention now, and which are important for this particular case, are: one, applies to a payment under a relevant act to any employee or former employee in accordance with a recommendation, decision or determination by a relevant authority. So a payment which is made in accordance with a recommendation or decision by a relevant authority. Now, a relevant authority would include the WRC and would include court. That payment is exempt. Secondly, a payment made in accordance with a settlement arrived at under a mediation process provided for in a relevant act shall be treated as if it had been made in accordance with a recommendation, decision or determination under that act of a relevant authority. Again, if the payment is made after a mediation process provided for in a relevant act, and that's very important, then it's possible or probable that the payment, the lump sum payment, is exempt. And then finally, the third category of exemption would be where a payment is made under an agreement evidenced in writing, being an agreement between persons who are not connected in settlement of a claim which, had it been made to a relevant authority, is likely to have been the subject of a recommendation, decision or determination under that act by a relevant authority, that a payment be made to the person making the claim. In other words, if the claim had been made to a relevant authority, again the WRC or the civil court, then the likelihood is that it would have resulted in a claim, a recommendation being made to make a payment to the employee. In those circumstances, those three specific circumstances, mediation, a claim that went in and which is now settled and is settled by way of an agreement, in circumstances where it would likely have resulted in a win for a recommendation in favour of the employee, or the first situation where the payment is recommended or a decision or a determination by a relevant authority recommends or states that a payment must be made. They are the exemptions. In this situation, when it went to the Tax Appeal Commission, the Tax Appeal Commission basically found that the payment was not tax-free, it was taxable. And the reason for that is essentially twofold. And I'm going to have a look at those now. Let me just bring them up here now and check the specific reasons. The reasons that the Tax Appeal Commissioner decided, or Tax Appeals Commissioner decided that the payment was taxable was that the severance agreement expresses in clear terms that it was made in full and final settlement of any claims arising from the employment, but it was made without any admission of a breach of statute or law by either party or a breach of any duty or obligation by the employer to the appellant. So the agreement made quite clear that the payment was being made without admission of liability. If that's the case, then the likelihood is that any claim which the employee made may not have succeeded, and in any event the employee, remember, never made any claim to the WRC or to civil courts or anywhere else. The second reason why the payment didn't come within one of the exemptions was that the mediation that they engaged in was mediation sort of agreed between the parties, but it wasn't mediation which was pursuant to a relevant act. And so it was mediation between the parties. It was entirely voluntary. They got in an external mediator into the workplace. They tried to come to some agreement, but that is not mediation under a relevant act. So here's the situation where the employee hadn't submitted any claim anyplace. Therefore, if he hadn't submitted any claim anyplace, it was unlikely that there would be a recommendation or a decision or a determination in his favour, because no such claim was made. And secondly, the mediation did not arise under or pursuant to a relevant act. It arose because the parties agreed it. And finally, and most tellingly, the Tax Appeals Commission said the very first place you should have a look at in this situation or in any dispute like this would be the severance agreement itself. And it said that the severance agreement expresses in clear terms that the appellant was being given notice of the termination of his employment and that his employer agreed to make a termination payment to the appellant. And the payment of 65 grand was described as a termination payment. The appellant agreed to accept the payment without any admission of a breach of statute or law by either party. All of those things meant that essentially the settlement arrived at between the parties, whilst it was a good one for the employee, perhaps it was taxable. And that's how the Tax Appeals Commissioner decided that the payment was taxable. That would be fairly sickening, quite frankly. And obviously there may well be a fair amount of tax. I don't know the individual circumstances, and there is certain exemptions in relation to tax depending on whether you made any claims or used up any exemption in previous years and so on and so forth. But in this particular case, the employee had an issue with the employer. They tried to sort out the issues in the workplace. It didn't succeed. There was a settlement or a termination agreement or a severance agreement, and it was purported that the 65 grand was tax-free and was exempt, when in fact, when the rubber hit the road, the Tax Appeals Commission decided no, the Revenue Commissioners were absolutely right. It was not a payment which was exempt, and was not exempt in accordance with the relevant exemptions in Section 192A of the Taxes Consolidation Act 1997. Hope you find this video useful. If you do, I'd appreciate if you give it a thumbs up down below. Thank you.